The sharp crack of Karen Whitmore's tennis racket against the pristine white ball echoed across the Platinum Heights Country Club like a gunshot. But that sound was nothing compared to the earth-shaking roar that would soon fill the valley when she discovered that building 35 luxury homes on someone else's property becomes very expensive when that someone controls the century-old dam system that can turn your illegal development into an artificial lake. But here's the thing about entitled HOA presidents who wear white tennis outfits like military uniforms and treat property law like suggestions. They never expect to meet someone who owns more engineering patents than most countries and has enough fuck you money to literally flood their suburban empire back to the Stone Age. By the time I finished documenting her systematic land theft and environmental destruction, this tennis-obsessed suburban dictator had lost everything she'd illegally built, faced federal charges for fraudulent construction, and learned the hard way that some tech billionaires don't just file lawsuits, they demonstrate hydraulic engineering principles in real time. Seriously, what would you do if some HOA Karen built an entire neighborhood on your private property while you were launching rockets, then tried to claim ownership through squatters' rights? Drop a comment and let me know where you're watching from. I need to see if this level of construction fraud exists in your area too. Let me back up and explain how this whole engineering nightmare started. My name is James Patterson, and I've been Elon Musk's executive assistant and project coordinator for 5 years. When you work for someone whose daily schedule includes revolutionizing electric vehicles, advancing space exploration, and developing brain-computer interfaces while managing a net worth that exceeds the GDP of small nations, you learn to expect the unexpected. But nothing, absolutely nothing, prepared me for dealing with Karen Whitmore and her pathological need to steal other people's land through creative property law interpretation. Elon had purchased his 2,400-acre Texas compound 3 years ago, a stunning piece of hill country real estate that included rolling pastures, ancient oak groves, a natural limestone cave system, and most importantly for this story, the headwaters and dam system for Willow Creek, a waterway that had been providing flood control and irrigation for the surrounding valley since 1924. The property, originally part of the massive Kellerman Ranch, came with water rights that predated the formation of Texas as a state. When German settlers built the original stone and earth dam in the 1880s, they created a system that collected seasonal rainfall and released it gradually to prevent downstream flooding while providing consistent water supply for farming and ranching operations throughout the valley. Elon's purchase included not just the land, but comprehensive water management responsibilities that were both a legal obligation and an engineering challenge that fascinated someone who'd spent his career solving complex technical problems. He'd actually bought the property partly because the dam system represented interesting hydraulic engineering principles that could potentially be applied to Mars terraforming projects. Karen Whitmore, meanwhile, lived in the Platinum Heights development that occupied Prime Valley real estate about 12 miles downstream from Elon's property. At 35, Karen had the kind of restless energy that comes from having inherited enough money to be dangerous but not enough intelligence to avoid catastrophic legal mistakes. Picture this. Karen's daily uniform consisted of pristine white tennis outfits from brands that cost more than most people's monthly rent, perfectly coordinated with white leather tennis shoes that never showed a scuff mark. Her platinum blonde hair was always styled in what expensive salons call the country club sophisticate, layered, highlighted, and shellacked into place with products that probably violated several environmental protection laws. She carried a white leather tennis bag everywhere, even when she wasn't headed to the courts, like some kind of suburban status symbol that announced her membership in the leisure class. Karen's morning routine was legendary throughout the hill country. She'd emerge from her $4.8 million Mediterranean-style mansion at exactly 7:15 a.m., wearing her tennis whites and designer sunglasses, driving her white BMW X7 to patrol what she considered her domain, which apparently included any property within a 50-mile radius that she found aesthetically interesting. As president of the Platinum Heights HOA, Karen wielded her authority like a medieval queen ruling over peasant subjects who existed solely for her approval or condemnation. She'd spent the past 8 years systematically expanding her control beyond the official HOA boundaries, claiming jurisdiction over neighboring properties through creative interpretation of watershed management agreements and environmental protection clauses. The trouble started 18 months ago when Karen discovered that a significant portion of the land she'd been coveting for community expansion was legally owned by someone with deeper pockets and better lawyers than the previous property owners she'd successfully bullied into submission. Here's where the timeline becomes crucial to understanding this story. While Elon was busy launching Starship prototypes and revolutionizing social media platforms, Karen was conducting what she called property development research on his upstream acreage. She'd drive her white BMW along the property boundaries, taking photographs and GPS coordinates while developing increasingly elaborate theories about underutilized land assets and community development opportunities. What Karen discovered was that Elon's 2,400 acres included nearly 800 acres of relatively flat, well-drained valley bottom that would be perfect for luxury residential development. The land had road access, existing utility easements, and most appealingly for Karen's vision, it was upstream from Platinum Heights in a location that would provide commanding views of the entire valley. Karen's research also revealed that Elon rarely visited the Texas property, spending most of his time at various SpaceX facilities, Tesla factories, and other business locations around the world. In Karen's entitled mind, this meant the land was essentially abandoned and therefore available for more productive use by someone who would properly develop and maintain it. Here's where Karen made her first catastrophic legal error. She convinced herself that Texas adverse possession laws, commonly known as squatters' rights, could be applied to Elon's property if she could establish continuous use and improvement for the required time period. Her interpretation of property law was about as accurate as her understanding of rocket science, but Karen had never let legal technicalities interfere with her suburban expansion plans. Karen's scheme was elegant in its simplicity and devastating in its illegal consequences. She would develop the upstream valley land through her husband Richard's construction company, sell the homes to carefully selected buyers who understood the unique ownership situation, and establish facts on the ground that would make any legal challenge expensive and time-consuming enough that even a billionaire might choose to settle rather than fight. The first phase began with what Karen called environmental assessment and improvement activities. Richard's construction crews began clearing brush, conducting soil tests, and installing temporary access roads under the pretense of wildfire prevention and watershed management. The activities were carefully designed to look like routine land management rather than preparation for major development. Phase 2 involved more aggressive improvements, grading building sites, installing utility infrastructure, and constructing permanent access roads. Karen justified these activities through a series of permits that she'd obtained by misrepresenting her relationship to the property and claiming authority through various environmental and agricultural management programs. By Phase 3, Karen was selling lots to buyers who were informed that the property was being developed through a special arrangement with the owner, and that final ownership transfers would be completed once certain legal formalities were resolved. The buyers, mostly wealthy retirees looking for luxury hill country estates, trusted Karen's assurances and focused on the stunning valley views rather than investigating the complex ownership situation. Within 14 months, Karen had sold 35 building lots for an average of $485,000 each, generating over $16 million in revenue that was split between her personal accounts, Richard's construction company, and a series of shell corporations she'd established to hide the scope of her operation. The houses themselves were impressive. $2.2 million luxury homes with 4 bedrooms, 5 bathrooms, 3-car garages, and infinity pools that seemed to spill directly into the valley landscape. Each home was positioned to maximize views of the surrounding hill country while maintaining privacy from neighboring properties. But Karen's entire operation was built on a foundation of lies, fraud, and spectacular misunderstanding of property law. Every house, every utility connection, every access road was constructed on land that legally belonged to Elon Musk, who had purchased clear title and maintained all property rights despite Karen's creative interpretation of abandonment and adverse possession statutes. The discovery came when Elon's legal team conducted their annual property survey and discovered that significant portions of his land had been developed without permission, notification, or any legal authority whatsoever. The aerial photographs showed 35 completed homes, extensive infrastructure development, and what appeared to be a thriving residential community on property that was supposed to be undeveloped ranch land. I was with Elon in his Austin office when our lead attorney, Patricia Santos, called with the initial report. Her voice carried the kind of carefully controlled outrage that comes from discovering massive fraud disguised as real estate development. "Elon, we have a significant problem with your hill country property," she began, her words measured but tense. "Someone has built an entire subdivision on your land without permission. 35 houses, full infrastructure, and apparently they're selling these homes to unsuspecting buyers." Elon's reaction was characteristically direct and engineering-focused. "How is that possible? Don't we have security systems and property monitoring?" Patricia explained that the development had been positioned in a valley area that wasn't covered by the main security systems, and the perpetrators had been careful to avoid the areas around Elon's primary residence and facilities. They'd also used legitimate-looking permits and construction materials to make their development appear authorized. "Who's responsible for this?" Elon asked, already shifting into problem-solving mode. "A woman named Karen Whitmore, who claims to be acting under various environmental and community development authorities. She's been selling lots and collecting millions in revenue while representing herself as having legal authority to develop your property." That's when Elon asked the question that would transform this from a simple trespassing case into an engineering demonstration that would make hydraulic textbooks. "What's the water situation for these houses?" Patricia consulted her notes. "They're connected to municipal water service, but the entire development is located in the floodplain for Willow Creek. Actually, it's directly downstream from your dam system." Elon was quiet for a long moment, and I could practically hear the gears turning as he processed the engineering implications. Someone had built 35 expensive houses in a flood zone directly below a dam system that he controlled, and that was specifically designed for flood management. "James," he said finally, "cancel my meetings for tomorrow. We need to visit the Hill Country property and assess this situation personally." As I rearranged his schedule and prepared for what would become the most expensive engineering demonstration in Texas real estate history, I couldn't help but appreciate the irony. Karen had stolen land from someone who'd built a career solving impossible engineering problems, and she'd placed her illegal development in the one location that would allow him to solve this particular problem through practical application of hydraulic principles. The war between Karen's fraudulent construction empire and Elon's legal property rights was about to become a very expensive lesson in the physics of water flow and the consequences of building homes in flood zones controlled by people who understand both property law and dam engineering. The drive through the Texas Hill Country that Tuesday morning felt like traveling through a real estate crime scene, with Karen Whitmore's fraudulent development sprawling across Elon's Valley like a suburban infection that had metastasized into $35 million tumors. But here's the thing about tech billionaires who discover that someone has built an entire neighborhood on their private property. They don't just call lawyers and file paperwork. They conduct engineering assessments and calculate hydraulic flow rates while developing solutions that combine legal justice with practical physics demonstrations. The metallic taste of adrenaline mixed with engineering curiosity as Elon stood at the overlook studying Karen's illegal empire through high-powered binoculars, his mind already calculating water volumes, dam capacity, and the precise flow rates needed to restore his property to its natural floodplain state. We arrived at the Hill Country compound at 9:47 a.m. in Elon's modified Tesla Model S Plaid, which he'd equipped with additional battery packs and all-terrain tires for ranch use. The vehicle's autopilot system navigated the winding ranch roads while Elon reviewed aerial photographs and engineering surveys on his tablet, muttering calculations about water displacement and structural engineering that sounded like he was planning a Mars colony rather than addressing suburban land theft. The view from the main ranch house overlooked the entire valley, and Karen's development was visible in stunning illegal detail. 35 luxury homes arranged in perfect suburban symmetry, each with manicured lawns that required massive irrigation, swimming pools that sparkled like jewels in the morning sunlight, and driveways filled with expensive cars owned by people who had no idea they were living on stolen property. "James," Elon said, handing me his binoculars, "document everything you see. I want precise GPS coordinates for every structure, every utility connection, every landscaping modification. This is going to become evidence in multiple federal cases." Through the binoculars, I could see the development in devastating detail. The houses were beautiful, architecturally consistent, and positioned to maximize valley views while maintaining privacy between neighbors. Solar panels gleamed on every roof, landscaping was mature and expensive, and the overall aesthetic was exactly what wealthy retirees would want from a luxury hill country estate. But I could also see the engineering problems that Karen had either ignored or never understood. The entire development sat in what was clearly a natural drainage basin, positioned directly in the path that water would take when released from the upstream dam system. Expensive retaining walls and drainage channels showed that someone had recognized the flood risk and attempted engineering solutions, but the modifications were clearly inadequate for the volume of water that the century-old dam system was designed to manage. "The engineering is terrible," Elon observed, taking back the binoculars and focusing on the drainage systems. "They've built expensive homes in a 100-year flood zone and tried to manage water flow with decorative landscaping and insufficient drainage infrastructure. This is a disaster waiting to happen even without intentional dam releases." That's when Patricia Santos called with an update that would transform our property survey into a criminal investigation coordination meeting. "Elon, I've been researching the permits and legal documentation for this development, she began, her voice tight with the kind of controlled fury that comes from discovering systematic fraud. Karen Whitmore obtained construction permits by forging property ownership documents and misrepresenting her authority to develop your land. She explained that Karen had created an elaborate web of false documentation, including forged deeds, fake environmental assessments, and fraudulent utility agreements. The buyers had been shown legitimate-looking paperwork that made the development appear legal and authorized. How much money is involved? Elon asked, already calculating the scope of the fraud. Over $16 million in lot sales, plus approximately $75 million in completed construction value. The buyers invested their life savings based on Karen's fraudulent representations. This isn't just trespassing, this is organized real estate fraud on a massive scale. But Patricia's most important discovery was about the water situation. Elon, the municipal water service that supplies these homes, is drawing from Willow Creek downstream from your dam. Karen's development is completely dependent on the water system that you control through your property rights. That's when the engineering solution became clear. The homes were built in a flood zone, supplied by water from a creek system that Elon legally controlled, and positioned in the exact location where natural flooding would occur if the dam system operated according to its original 1924 design specifications. James, call the county engineering office and request all historical documentation for the Willow Creek dam system, Elon instructed, his voice carrying the focused intensity that appeared whenever he identified an interesting technical problem. I want to understand exactly how this system was designed to operate and what the seasonal flooding patterns are supposed to be. Within 2 hours, I'd obtained comprehensive engineering documentation showing that the dam system was specifically designed to collect seasonal rainfall and release it gradually to prevent downstream flooding while providing irrigation water during dry periods. The historical records included detailed flow calculations, seasonal release schedules, and maintenance protocols that had been followed for nearly a century. But most importantly, the documentation proved that Karen's development had been built in an area that was designated as seasonal floodplain, specifically marked as unsuitable for permanent structures due to periodic water releases from the upstream dam system. She built luxury homes in a designated flood zone, Elon said, reviewing the historical engineering reports. Either she knew about the flood risk and ignored it, or she never bothered to research the water management system for the area. Either way, it's criminally negligent. That afternoon, we drove down to inspect Karen's development more closely. The houses were even more impressive at ground level: custom architecture, expensive finishes, and mature landscaping that must have cost hundreds of thousands per property. But I could also see the signs of hasty construction and inadequate environmental planning that Elon's engineering eye had identified from the overlook. That's when we encountered Karen herself, conducting what appeared to be her daily inspection tour in her white BMW X7, wearing her standard white tennis outfit, and carrying her ever-present white leather tennis bag like some kind of suburban royal scepter. Karen's reaction to seeing strangers on her development was immediate and characteristically aggressive. She pulled up beside our Tesla in a cloud of dust and indignation, her window already down and her voice ready for confrontation. "Excuse me," she called out, her tone carrying the kind of entitled authority that comes from never being told no by anyone who matters. "This is private property. You're trespassing on Platinum Heights Valley Estates." Elon's response was measured, professional, and devastating in its legal implications. "Actually, this is my private property. I'm Elon Musk, and you've built 35 houses on land that I own legally and completely." The silence that followed was the kind you hear right before thunder splits the sky. Karen's face went through several interesting color changes as she processed what she'd just heard, her white tennis visor casting dramatic shadows across her increasingly pale features. "That's impossible," she finally managed, her voice rising to the pitch that wealthy white women use when reality doesn't conform to their expectations. "I have all the permits and legal documentation for this development. This land was abandoned and available for community improvement. Ma'am, I have clear title to this entire valley, purchased 3 years ago with comprehensive water rights and development restrictions," Elon replied calmly. "Every structure you've built is on my property without permission, authorization, or legal right." Karen's transformation from confident developer to desperate fraud was almost instantaneous. "You can't prove that. I have lawyers. I have connections with the county government. This development has been approved through all proper channels." That's when Elon made the strategic decision that would escalate this from a civil property dispute into a federal criminal investigation. "Ma'am, I'm going to need you to provide all documentation supporting your claimed authority to develop this property. My legal team will review your permits, deeds, and ownership claims to determine how this situation should be resolved." Karen's response revealed everything about her mental state and her understanding of the legal disaster she'd created. "I don't have to provide anything to you. This is harassment. I'm calling the police." She actually did call the police, right there in front of us, while sitting in her BMW wearing her white tennis outfit and speaking in the kind of shrill tone that makes 911 dispatchers check their caffeine levels. "I need officers immediately at Platinum Heights Valley Estates," she told the dispatcher. "Unknown men are trespassing on private development property and making threatening demands for documentation." Sheriff Deputy Michael Rodriguez arrived 20 minutes later, and his investigation would become the foundation for multiple federal fraud prosecutions. He reviewed Elon's property documentation, Karen's development permits, and the GPS coordinates that confirmed every house was built on Elon's legally owned land. "Ma'am, these gentlemen have clear legal title to this property," Deputy Rodriguez explained to Karen, whose white tennis outfit was now showing stress stains and whose carefully styled hair was beginning to show the effects of her emotional meltdown. "Your development permits appear to be based on fraudulent property ownership claims." Karen's reaction was immediate and spectacularly self-incriminating. "Those documents are fake. He's trying to steal my development through fraudulent legal papers. This is organized crime." Deputy Rodriguez's report, filed that evening, would document Karen's admission that she'd been operating the development based on questionable documentation, her claims that legitimate property deeds were fraudulent, and her threats to use political connections to override legal property rights. But Karen wasn't done escalating. As Deputy Rodriguez prepared to leave, she made the strategic error that would transform this from a property dispute into a comprehensive criminal investigation. "You don't understand who you're dealing with," she told Elon, her voice carrying the kind of desperate threats that people make when they realize they're completely outmatched. "I have investors, contractors, and buyers who have millions invested in this development. If you think you can just take it away, you're going to learn about Texas property law the hard way." Elon's response was characteristically direct and ominous in its legal implications. "Ma'am, I think you're the one who's going to learn about Texas property law. Starting tomorrow, my legal team will be filing comprehensive fraud charges with federal prosecutors. Building homes on someone else's land and selling them to unsuspecting buyers is serious federal crime." As Karen drove away in her white BMW, still screaming threats and promises about political connections and legal retaliation, I realized this wasn't going to end with simple property restoration. Karen had created a criminal enterprise built on systematic fraud, and Elon had just declared war on someone who'd apparently never face consequences for her entitled behavior. The next morning would bring federal investigators, detailed engineering assessments, and the beginning of a legal process that would not only restore Elon's property, but demonstrate exactly what happens when someone tries to steal land from people who understand both property law and hydraulic engineering. Karen had built her illegal empire in a flood zone controlled by someone with the resources and knowledge to restore it to its natural state. The engineering demonstration was about to begin, and it would be educational for everyone involved. The federal investigators arrived at dawn like a coordinated military operation, with FBI vehicles, IRS agents, and Environmental Protection Agency officials forming a convoy that stretched from the main ranch house to Karen's fraudulent development like a law enforcement parade, announcing the end of her criminal real estate empire. But here's the thing about entitled HOA presidents who build illegal subdivisions while wearing white tennis outfits and assuming their country club connections provide immunity from federal prosecution. They never realize that defrauding buyers out of $91 million creates the kind of evidence trail that makes prosecutors smile with the satisfaction of people holding winning lottery tickets. The crisp morning air carried the sound of Karen's BMW racing through her development at speeds that would normally trigger HOA violations if she hadn't just discovered that her HOA authority was about to be replaced by federal criminal charges and asset forfeiture proceedings. FBI Special Agent Maria Santos arrived with the kind of comprehensive documentation package that defense attorneys have nightmares about. She'd spent 18 hours reviewing Patricia's legal filing, Karen's fraudulent permits, and the property records that revealed the full scope of the organized real estate fraud that had been operating for over a year. "Musk," Agent Santos began, spreading evidence folders across the dining room table like a prosecutor organizing her opening statement. What we have here is systematic real estate fraud involving forged documents, false representations to buyers, fraudulent permit applications, and conspiracy to commit wire fraud across state lines. She explained that Karen's scheme involved multiple federal crimes because she'd used interstate banking systems to process fraudulent sales, mailed false documents to out-of-state buyers, and created shell corporations to hide the illegal proceeds. Each element added additional charges and potential prison time that could keep Karen in federal custody until her hair returned to its natural color. How many people were defrauded? Elon asked, already calculating the scope of victim impact and potential civil liability. 35 families purchased homes totaling $77 million based on Karen's false representations, Agent Santos replied. Most buyers used their retirement savings or sold previous homes to fund purchases. Several families relocated from other states specifically for these properties. But Agent Santos's most significant finding was about the environmental fraud that Karen had committed to make her development appear legitimate. She falsified wetlands assessments, groundwater studies, and flood zone evaluations to obtain construction permits. The environmental damage from building in protected floodplain areas adds federal environmental crimes to the charges. That's when Elon asked the question that would transform this investigation from routine fraud prosecution into an engineering demonstration that would make hydraulic textbooks. What happens to the homeowners who innocently purchased these properties? Agent Santos consulted her files. Under federal restitution requirements, the properties will likely be demolished and the land restored to its natural state. Innocent buyers will recover their investments through criminal restitution and civil asset forfeiture from Karen's illegal proceeds. How long would that process take? Elon continued, his engineering mind already calculating alternative solutions. Typically 18 to 24 months for complete resolution, assuming Karen cooperates with asset recovery. If she fights the charges, it could take 3 to 5 years. Elon was quiet for a moment, processing the timeline implications for both the innocent homeowners and the environmental restoration requirements. Then he made the decision that would accelerate Karen's legal nightmare from a slow bureaucratic process into a rapid engineering demonstration. Agent Santos, what if I could restore the property to its natural state while providing immediate resolution for the defrauded homeowners? He asked, his voice carrying the focused intensity that appeared when he identified interesting technical challenges. She looked intrigued but cautious. What kind of resolution are you considering? The dam system on my property was designed in 1924 to manage seasonal flooding for this exact valley area. If I operated according to original specifications during the next heavy rain period, it would demonstrate the natural flood patterns that make this area unsuitable for residential development. Agent Santos understood immediately. You're talking about controlled flooding to prove that these houses were built in a flood zone. Exactly. It would provide compelling evidence for environmental fraud charges while demonstrating why the homes need to be relocated. And if I purchased the homes from the innocent buyers at their full purchase price, they could avoid the lengthy restitution process. The plan was brilliant in its simplicity and devastating in its legal implications. Elon would demonstrate that Karen had built homes in a natural flood zone by allowing the century-old dam system to operate as designed. The controlled flooding would prove environmental fraud, provide evidence for federal charges, and create urgency for immediate property buyout and relocation. Meanwhile, Karen was conducting her own crisis management meeting at the Platinum Heights Country Club, wearing a fresh white tennis outfit that would soon be replaced by federal prison orange. Her emergency HOA board meeting included her husband Richard, their construction company attorney, and 3 board members who were about to discover they'd been unwitting participants in organized fraud. This is obviously a shakedown by some tech billionaire who thinks he can buy his way into our community, Karen announced to her assembled supporters, her voice carrying the kind of desperate confidence that comes from complete denial of reality. He's using fake legal documents and corrupt federal agents to steal our legitimate development. Richard Whitmore, who'd built the houses without realizing his wife had forged the property ownership documentation, was experiencing the kind of dawning horror that comes from discovering you've been an unwitting accomplice in massive fraud. Karen, I need to see the original property deeds and ownership transfers, he said, his voice tight with growing panic. If there's any question about legal authority to build these homes, our construction company could face criminal charges. Karen's response revealed the full extent of her delusional thinking and complete misunderstanding of the legal disaster she'd created. Richard, don't let them intimidate you with their fake legal papers. I have documentation proving our rights to this property through adverse possession and environmental improvement statutes. The documentation she presented was a masterpiece of creative forgery and legal misinterpretation. Fake deeds with forged signatures, environmental permits based on false information, and adverse possession claims that ignored the basic legal requirement of open and notorious use for the statutory period. Board member Patricia Goldman, a retired real estate attorney, reviewed the documents with growing alarm. "Karen, these deeds are obviously fraudulent, the signatures don't match, the notary stamps are incorrect, and the adverse possession claims have no legal foundation. This entire development is built on forged documentation." That's when Karen made the strategic error that would transform her fraud charges into federal conspiracy charges involving multiple co-conspirators. "Patricia, I need you to support the HOA's position publicly. We all have millions invested in this community, and we can't let some outsider destroy our property values." She was asking Patricia to participate in covering up fraud, making public false statements about property ownership, and joining a conspiracy to defraud federal investigators. Patricia's response was immediate and decisive. "Karen, I'm resigning from the board effective immediately and consulting with my attorney about criminal liability for anyone who participated in this fraud." She gathered her papers and walked out, leaving Karen with a board meeting that would be cited in federal conspiracy charges. But Karen wasn't done making self-incriminating statements. As her remaining board members expressed increasing concern about criminal liability, she escalated her threats and promises in ways that federal prosecutors would later describe as a defendant creating her own evidence. "If anyone cooperates with these federal investigators, they'll regret it," she announced, apparently unaware that Patricia was recording the meeting for legal protection. "I have connections in Austin and Washington who can make problems disappear for loyal community members and create serious problems for disloyal ones." The recordings, later provided to federal investigators, captured Karen threatening witnesses, promising to use political connections to obstruct federal investigations, and admitting that her development authority was based on questionable documentation. "Meanwhile, I was coordinating with meteorologists about upcoming weather patterns that would provide optimal conditions for Elon's engineering demonstration. The National Weather Service predicted a significant rain system arriving in 5 days, with precipitation totals that would test the dam system's capacity and provide natural justification for controlled water releases. James, contact all 35 homeowners and schedule individual meetings to discuss property purchase offers," Elon instructed, his planning shifting into the systematic mode that had built multiple billion-dollar companies. "I want to buy every home at full purchase price plus relocation expenses before the federal asset seizure process begins." The homeowner meetings were scheduled for the next 3 days, and the responses revealed the full human cost of Karen's fraud. Retired couples who'd invested their life savings, young families who'd relocated from other states for their dream homes, small business owners who'd planned their retirement around these properties. But they were also relieved to discover that they wouldn't face financial ruin due to Karen's criminal behavior. Elon's purchase offers provided full recovery of their investments, plus generous relocation assistance that would help them find legitimate homes in areas that weren't built on stolen land. The most revealing meeting was with Robert and Margaret Chen, the elderly couple who'd purchased Lot 15 for $520,000 using their retirement savings. They'd been suspicious of Karen's explanations about the complex ownership situation, but had trusted her assurances about legal resolution. "Mr. Patterson, we knew something wasn't right when Karen kept delaying the final ownership transfers," Margaret explained. "But we'd already invested so much and the house is beautiful, so we hoped everything would work out." Their relief at learning about Elon's purchase offer was obvious, but their anger at Karen's deception was even stronger. "That woman stole our retirement security and risked our financial future for her illegal schemes," Robert said. "I hope federal prosecutors give her the maximum sentence." By the end of the 3rd day, all 35 families had agreed to Elon's purchase offers. The total buyout cost was $84 million, but it provided immediate resolution for innocent fraud victims while creating compelling evidence of the scope of Karen's criminal enterprise. That's when Agent Santos called with the news that would accelerate Karen's legal nightmare from federal investigation into comprehensive prosecution with international implications. "Mr. Musk, our financial investigation has uncovered additional fraud involving Karen's international shell corporations and offshore accounts," she explained. "The money laundering and tax evasion charges will likely add another 10 to 15 years to her potential sentence." Karen had been hiding illegal proceeds in foreign accounts while claiming poverty to avoid civil lawsuits from previous victims of her real estate schemes. The international banking records showed systematic patterns of fraud going back 7 years, involving multiple properties and dozens of additional victims. "How soon can you complete the homeowner relocations?" Agent Santos asked. "We'd like to execute search warrants and asset seizures while the evidence is still fresh and before Karen can destroy additional documentation. All families will be relocated within 10 days, Elon confirmed. "After that, you're welcome to use my property for any law enforcement activities, including demonstrations of the natural flooding patterns that make this area unsuitable for residential development." The trap was set, the evidence was documented, and the innocent victims were protected. All that remained was the engineering demonstration that would prove Karen had committed environmental fraud by building luxury homes in a designated flood zone. The weather forecast predicted heavy rains in 48 hours, and Karen was about to learn that some technical problems have solutions that combine legal justice with practical physics demonstrations that restore natural water flow patterns while providing evidence for federal criminal prosecution. The storm system approaching from the Gulf of Mexico carried the kind of meteorological power that weather services describe in ominous terms like significant precipitation event and potential flooding conditions. But for Elon, it represented the perfect natural laboratory for demonstrating century-old hydraulic engineering principles while providing compelling evidence that Karen Whitmore had built $77 million worth of luxury homes in a designated flood zone. But here's the thing about entitled real estate fraudsters who spend their final days of freedom wearing white tennis outfits and threatening federal investigators. They never realize that Mother Nature doesn't care about your country club connections when 48 hours of rainfall test the dam system that some tech billionaire controls with the precision of a rocket engineer and the patience of someone who spent years launching satellites into perfect orbital trajectories. The National Weather Service forecast predicted 6 to 8 inches of rainfall over 48 hours, with peak precipitation rates that would test the dam's capacity and provide optimal conditions for demonstrating natural seasonal flooding patterns that had been documented for over a century. Elon's engineering team had calculated precise water volumes, flow rates, and release schedules that would restore the valley to its natural floodplain state while providing irrefutable evidence of environmental fraud. "James, coordinate with Agent Santos about media coverage for the demonstration," Elon instructed as he reviewed final engineering calculations on his tablet. "This needs to be documented comprehensively for both federal prosecution and public education about floodplain development restrictions." Agent Santos had arranged for multiple federal agencies to observe what she officially termed natural flood pattern restoration demonstration. EPA officials would document environmental law violations, Army Corps of Engineers representatives would validate the hydraulic engineering, and Justice Department prosecutors would record evidence for federal fraud trials. But the most important observers would be the news media, who would broadcast Karen's engineering catastrophe to millions of viewers as an educational demonstration about the consequences of building expensive homes in flood zones controlled by people who understand both water management and property law. Meanwhile, Karen was conducting her final acts of criminal obstruction at the Platinum Heights Country Club, wearing what would become her last white tennis outfit before trading it for federal prison orange. Her emergency meeting with remaining supporters revealed the full extent of her psychological deterioration and complete disconnect from legal reality. "The federal agents are obviously corrupt," she announced to her audience of 3 remaining board members and her increasingly desperate husband, Richard. "This tech billionaire thinks he can buy the justice system to steal our legitimate development, but we have rights that money can't purchase." Richard Whitmore had spent 3 sleepless nights consulting with criminal defense attorneys who'd explained that his construction company faced potential conspiracy charges, asset forfeiture, and civil liability that could bankrupt multiple generations of his family. His response to Karen's continuing delusions was the sound of a man watching his life collapse in real time. "Karen, our attorneys say we need to cooperate with federal investigators and negotiate plea agreements immediately," he said, his voice carrying the defeated tone of someone who'd finally realized the scope of the disaster. "Every day we delay cooperation adds years to potential prison sentences." Karen's reaction revealed that her denial had evolved into complete psychotic break from reality. "Richard, you're letting them intimidate you with fake legal threats. I have connections in Washington who can make these charges disappear if we stand strong and don't admit to anything." She actually believed her country club social connections could override federal fraud prosecution. The woman who'd built homes on someone else's property was convinced that her tennis partners had enough political influence to stop Justice Department prosecutors from pursuing cases involving $91 million in documented fraud. Board member David Morrison, who'd been reviewing his own criminal liability exposure, made the decision that would provide federal prosecutors with their final piece of evidence about Karen's criminal conspiracy and obstruction attempts. "Karen, I'm recording this meeting for legal protection," he announced, placing his phone on the table. "If you continue making statements about obstructing federal investigations, I need documentation that I oppose these activities." Karen's response was captured in digital clarity that would later be played for federal juries as evidence of unrepentant criminal behavior and complete lack of remorse. "David, if you cooperate with these corrupt federal agents, I'll make sure everyone knows you were part of the fraud from the beginning," she threatened, apparently unaware that she was confessing to fraud while threatening a federal witness. Loyal community members protect each other, and disloyal ones face consequences. The recording captured Karen admitting to fraud, threatening federal witnesses, and promising to use unspecified connections to obstruct justice. Defense attorneys would later describe it as the most self-incriminating evidence in federal prosecution history. But Karen wasn't finished destroying her legal defense. As David Morrison gathered his papers and prepared to contact federal authorities, she made the strategic error that would add organized crime charges to her already comprehensive federal indictment. "Richard, contact our people in the construction union and make sure this David Morrison understands what happens to people who betray community interests," she instructed, apparently believing that union connections could intimidate federal witnesses. Richard's response was immediate and decisive. "Karen, I'm filing for divorce and emergency separation of assets. I will not participate in witness intimidation or obstruction of federal investigations." He walked out of the meeting, leaving Karen with no allies, no legal strategy, and a recorded confession that federal prosecutors would use to demonstrate systematic criminal behavior spanning multiple years and involving dozens of co-conspirators. That evening, as the first bands of rain began falling across the hill country, Elon's engineering team conducted final preparations for the controlled flooding demonstration. The dam system had been inspected, flow rates calculated, and release schedules coordinated with downstream emergency services to ensure public safety during the demonstration. The historical engineering documentation proves this valley floods naturally during significant rain events, explained Dr. Sarah Kim, the Army Corps hydraulic engineer who designed the demonstration protocol. "We're simply operating the dam system according to its original 1924 specifications to restore natural water flow patterns." Agent Santos had positioned multiple camera crews to document the flooding from various angles, creating comprehensive evidence for federal prosecution while providing educational content about floodplain development restrictions and environmental law violations. But the most compelling camera position was the aerial drone that would capture Karen's entire illegal development being restored to its natural floodplain state in real time, providing visual evidence that her luxury homes had been built in an area that nature intended to be underwater during seasonal precipitation events. At 6:30 a.m., as rainfall intensified across the watershed, Elon authorized the first controlled release from the dam system. The release was gradual, scientific, and designed to demonstrate natural flooding patterns while providing maximum educational and evidentiary value. Within 2 hours, water began pooling in the valley areas where Karen had built her most expensive homes. The luxury properties with their infinity pools and manicured landscaping slowly disappeared beneath rising water that followed the exact patterns documented in century-old engineering studies. The irony was visually stunning. Karen had built million-dollar homes with infinity pools that were now disappearing into an actual infinity of floodwater, controlled by someone who understood both hydraulic engineering and property law. The expensive retaining walls and drainage systems that she'd installed to manage water flow were completely overwhelmed by the volume of water that the dam system was designed to release during natural flooding events. By noon, 35 luxury homes were sitting in 4 feet of water that was continuing to rise at precisely calculated rates. The flooding wasn't destructive or dangerous, it was educational, demonstrating exactly why building codes prohibited residential development in designated floodplains. Karen's reaction to watching her criminal empire disappear beneath controlled flooding was captured by news crews and would become viral video content viewed by millions of people interested in the consequences of environmental fraud and property law violations. She stood on high ground wearing her white tennis outfit and designer rain gear, screaming at federal agents and news cameras about corruption, conspiracy, and the systematic persecution of honest community developers by corrupt tech billionaires with government connections. "This is environmental terrorism," she shrieked, pointing at her flooded development while rain soaked through her expensive tennis visor. "He's destroying legitimate homes to cover up his illegal land grab. This is organized crime." Agent Santos's response, captured on multiple cameras and broadcast worldwide, became a classic example of federal law enforcement professionalism under pressure. "Ma'am, this flooding demonstrates natural water patterns for this valley area. Your homes were built in a designated floodplain in violation of federal environmental laws. The demonstration proves that your development permits were based on fraudulent environmental assessments." Karen's final public statement before her arrest was a masterpiece of self-incrimination disguised as righteous indignation. "I don't care about your fake environmental laws. I built beautiful homes for families who deserved luxury living. If that's a crime, then this country has lost its values." The statement, broadcast live on multiple news networks, captured Karen admitting to violating environmental laws while claiming that her personal aesthetic preferences overrode federal regulations designed to protect both human safety and natural ecosystems. As federal agents approached with arrest warrants, Karen made one last desperate attempt to maintain her narrative of victimization and persecution. "This is what happens to Americans who dare to challenge tech billionaire corruption," she shouted while being handcuffed next to her flooded development. "They use fake environmental laws and corrupt federal agencies to destroy honest businesses." The visual impact was devastating for her defense strategy. Karen being arrested in her rain-soaked white tennis outfit while standing next to luxury homes that were obviously built in a flood zone created exactly the kind of compelling evidence that federal prosecutors dream about and defense attorneys have nightmares about. But the engineering demonstration wasn't finished. Over the next 12 hours, as rainfall continued and water levels rose according to precise calculations, the entire scope of Karen's environmental fraud became visible through aerial footage that would be used in congressional hearings about floodplain development restrictions. 35 homes, swimming pools, tennis courts, and manicured landscaping disappeared beneath water that followed natural drainage patterns documented in engineering studies from 1924. The demonstration proved beyond doubt that Karen had built a luxury development in an area that nature intended to be underwater during seasonal precipitation events. The controlled flooding would continue for 72 hours, providing comprehensive documentation of natural floodplain behavior while offering compelling visual evidence that Karen's criminal enterprise had endangered both human safety and environmental protection through systematic fraud and environmental law violations. As Karen began her journey from luxury tennis club lifestyle to federal prison accommodations, her illegal development remained underwater, serving as an educational monument to the consequences of building expensive homes in flood zones controlled by people who understand hydraulic engineering and aren't afraid to demonstrate natural water flow patterns in real time. Federal District Court Judge Patricia Williams had seen enough white-collar criminals in her 20-year judicial career to recognize when someone was about to receive what legal scholars call the full weight of federal prosecution. But even she seemed taken aback by the comprehensive scope of evidence that prosecutors had assembled against Karen Whitmore in just 72 hours. The defendant's soggy white tennis outfit had been replaced by standard Orange County jail attire that clashed spectacularly with her fading blonde highlights, creating the kind of visual contrast that makes law students study the transformation from suburban privilege to federal prosecution. The courtroom smelled like wet concrete and broken dreams, as Karen shuffled through her arraignment hearing in shackles, apparently still convinced that her country club connections would somehow override $91 million in documented fraud and 3 days of internationally broadcast flooding that had turned her criminal enterprise into an educational demonstration about floodplain development violations. The federal prosecution team, led by Assistant U.S. Attorney Michael Rodriguez, presented what legal experts would later describe as one of the most comprehensive fraud cases in Texas federal court history. The evidence included 347 individual counts spanning real estate fraud, environmental crimes, money laundering, witness intimidation, and organized criminal conspiracy involving 43 co-conspirators across multiple states. "Your Honor," Rodriguez addressed Judge Williams while gesturing toward evidence displays that covered 3 walls of the courtroom. "The defendant operated a systematic criminal enterprise for over 18 months, defrauding 77 innocent families out of their life savings while violating federal environmental laws designed to protect both human safety and natural ecosystems." The prosecution's opening statement methodically outlined Karen's escalation from property envy to organized criminal conspiracy, using her own recorded statements and social media posts as evidence of premeditated fraud designed to steal land, defraud buyers, and destroy environmental protections through systematic corruption of permitting processes. "Ladies and gentlemen, the evidence will show that Mrs. Whitmore didn't make mistakes or exercise poor judgment," Rodriguez continued, his voice carrying the kind of prosecutorial confidence that comes from having recorded confessions and live television footage of the defendant's crimes. She organized a comprehensive criminal conspiracy involving forged documents, false representations to federal agencies, and systematic fraud designed to generate millions in illegal profits. The evidence presentation lasted 6 hours and included video footage of Karen's development being restored to its natural floodplain state, demonstrating conclusively that she'd built luxury homes in areas that were scientifically documented as unsuitable for residential construction. But the most damaging evidence was Karen's own recorded statements during her final HOA meetings, where she'd admitted to fraud, threatened federal witnesses, and promised to use criminal connections to obstruct justice. The recordings, played in their entirety for the packed courtroom, revealed a defendant who'd escalated from real estate fraud into organized crime while documenting her own criminal intent. Karen's defense attorney, Thomas Bradford, faced what legal professionals call an impossible client situation, where the defendant had created comprehensive evidence of her own guilt while refusing to acknowledge any criminal behavior. Bradford's opening statement was a masterpiece of legal desperation disguised as constitutional advocacy. "Your Honor, my client was operating under good faith belief that her development activities were legally authorized," Bradford argued, apparently hoping the jury would ignore the recorded evidence of Karen admitting to fraudulent documentation. Mrs. Whitmore believed she was improving abandoned property for community benefit, not committing federal crimes. The defense strategy collapsed within minutes when Rodriguez presented Karen's own recorded statements, acknowledging that her permits were questionable and her property ownership claims were based on creative legal interpretations. The defendant had literally confessed to fraud while trying to recruit co-conspirators for witness intimidation. Judge Williams' reaction to the evidence was immediate and decisive. "Mr. Bradford, your client organized systematic fraud involving forged federal documents, threatened federal witnesses, and operated criminal enterprises across state lines. These aren't good faith mistakes. These are serious federal crimes with mandatory minimum sentences." The bail hearing was equally devastating for Karen's defense. Rodriguez presented evidence of Karen's threats against witnesses, her attempts to hide assets in offshore accounts, and her statements about using criminal connections to obstruct federal investigations. "Your Honor, the defendant represents a clear flight risk and ongoing danger to federal witnesses," Rodriguez argued. "She's threatened multiple cooperating witnesses and has demonstrated access to criminal organizations willing to intimidate federal investigators." Judge Williams' denial of bail was comprehensive and legally devastating. The defendant has organized systematic fraud exceeding $90 million, threatened federal witnesses, and demonstrated clear intent to obstruct ongoing investigations. Bail is denied, and the defendant will remain in federal custody pending trial. Karen's reaction to denied bail provided her final moment of self-incrimination in federal court. She stood up in her orange jumpsuit and screamed at Judge Williams with the kind of entitled fury that makes federal judges very interested in maximum sentencing guidelines. "This is persecution of successful Americans by corrupt tech billionaires and their government puppets," she shrieked, apparently believing that attacking a federal judge would improve her legal situation. "I built beautiful homes for families who deserved luxury living. If that's criminal, then this country has abandoned its values." Judge Williams calmly instructed bailiffs to remove Karen from the courtroom while adding contempt charges to her already comprehensive federal indictment. Karen's final words before being dragged away would later be quoted in legal textbooks as an example of defendant self-destruction in federal court. "I'll never apologize for protecting community values from tech billionaire corruption." Meanwhile, the environmental assessment of Karen's former development site was revealing the full scope of ecological damage that her fraud had caused to protected wetlands and natural flood control systems. EPA investigators documented systematic destruction of native habitats, contamination of groundwater systems, and illegal modification of natural drainage patterns that had disrupted ecosystem balance throughout the valley. The environmental crimes added additional federal charges carrying up to 20 years in prison and millions in restoration costs that would bankrupt Karen's family for generations. Environmental law violations are among the most seriously prosecuted federal crimes because they affect entire ecosystems and can cause permanent damage to natural resources. Dr. Sarah Kim, the Army Corps engineer who designed the flooding demonstration, testified about the systematic environmental destruction that Karen's development had caused to natural water management systems. The defendant's construction activities destroyed wetlands that had provided natural flood control for over 2 centuries, Dr. Kim explained to the grand jury. The ecological damage will require comprehensive restoration efforts costing millions of dollars and decades of environmental monitoring. But the most significant testimony came from the 35 families who'd been defrauded by Karen's systematic real estate fraud. Their victim impact statements revealed the human cost of white-collar crime that extends far beyond financial losses. Robert and Margaret Chen, the elderly couple who'd invested their retirement savings in Karen's fraudulent development, provided testimony that brought federal prosecutors and courtroom observers to tears. "Your Honor, we trusted Mrs. Whitmore because she presented herself as a community leader and successful businesswoman," Margaret explained, her voice breaking with emotion. "We invested our life savings and moved from California based on her promises about legal ownership and community stability. The stress of discovering we'd been defrauded has affected our health, our marriage, and our faith in the American dream." Similar testimony from 34 other families painted a devastating picture of systematic fraud that had destroyed retirement security, forced families into bankruptcy, and traumatized children who'd lost their homes due to their parents' trust in Karen's criminal misrepresentations. The grand jury deliberated for 37 minutes before returning a comprehensive indictment, including 428 individual federal charges against Karen and her co-conspirators. The charges included major fraud against the United States, environmental crimes, money laundering, witness intimidation, and organized criminal conspiracy under federal RICO statutes. Federal sentencing guidelines for Karen's crimes indicated a potential prison sentence of 45 to 60 years, essentially a life sentence for a 35-year-old defendant. The financial penalties could exceed $200 million, ensuring that Karen's family would face bankruptcy and asset forfeiture that would continue for decades. Karen's co-conspirators faced varying charges based on their cooperation levels and degrees of participation. Richard Whitmore, who'd cooperated fully with federal investigators after discovering the scope of his wife's fraud, received a plea agreement for 18 months in minimum security prison and comprehensive restitution payments to defrauded homeowners. The other construction contractors and co-conspirators who'd participated unknowingly in Karen's fraud received reduced sentences in exchange for cooperation and testimony against the primary defendants. Only Karen and 3 close associates who'd knowingly participated in the systematic fraud faced potential life sentences. But Karen's legal troubles were expanding beyond federal criminal charges. The state of Texas filed additional charges for real estate fraud, environmental destruction, and organized criminal activity. Multiple civil lawsuits sought damages exceeding $500 million from victims, environmental groups, and governmental agencies responsible for ecological restoration. Karen's assets, including her mansion, vehicles, jewelry, and offshore accounts, were seized under federal asset forfeiture laws. The seized assets would be used to compensate fraud victims and fund environmental restoration, but they represented only a fraction of the total damages caused by her criminal enterprise. The most devastating blow to Karen's defense came when her own family members began cooperating with federal prosecutors. Her sister Patricia provided testimony about Karen's systematic lying and manipulation of family members to fund her criminal activities. Her elderly parents testified about Karen stealing from their retirement accounts to finance her development fraud. "Karen has been lying to us for years about her business activities," her father testified during the grand jury proceedings. "She convinced us to invest our savings and mortgage our home to support what she claimed were legitimate real estate ventures. We lost everything because we trusted our daughter's criminal lies." The family testimony revealed that Karen's fraud had extended beyond her development scheme into systematic exploitation of family members, friends, and business associates who'd been manipulated into funding her criminal activities through false representations and emotional manipulation. As Karen sat in federal custody awaiting trial, wearing orange jumpsuits instead of white tennis outfits, and writing delusional appeals that courts routinely dismissed, the environmental restoration of her former development site continued under federal supervision. The flooded valley had been allowed to drain naturally, revealing the ecological damage that Karen's construction had caused to natural habitats and water management systems. Native vegetation was replanted, wetlands were restored, and natural drainage patterns were re-established to prevent future flooding of downstream communities. The restoration project became a model for environmental recovery from illegal development, demonstrating how natural systems can be restored even after systematic destruction by criminal enterprises motivated by greed and environmental indifference. More importantly, the comprehensive federal prosecution sent a clear message to other potential real estate fraudsters about the consequences of environmental crimes and systematic fraud. The case established new precedents for environmental prosecution and victim compensation that would protect future communities from similar criminal schemes. Karen Whitmore had transformed from a tennis club queen to a federal prisoner, from a luxury homeowner to a bankrupted criminal defendant, and from a community leader to a cautionary tale about the consequences of systematic fraud and environmental destruction, the lesson was comprehensive and permanent. Federal environmental laws exist to protect both human safety and natural ecosystems, and violating them to generate illegal profits results in devastating criminal consequences that extend far beyond individual defendants to affect entire families and communities for generations. The Federal Correctional Institution at Seagoville smelled like industrial disinfectant and institutional despair when Karen Whitmore arrived wearing federal prison transport shackles instead of her signature white tennis outfit. Her once perfect blonde highlights, now showing 6 months of dark roots that matched the growing darkness in her delusional worldview. But here's the thing about entitled real estate fraudsters who discover that federal prison commissaries don't stock designer tennis gear, and cellmates aren't impressed by country club social connections. They either learn humility through comprehensive reality checks, or spend their sentences writing increasingly unhinged appeals that federal judges dismiss faster than bad engineering proposals. The harsh fluorescent lighting that never dimmed made Karen's fading spray tan look like old leather, while her attempts to maintain suburban superiority among convicted felons created the kind of pathetic spectacle that makes criminology professors assign case studies about the psychology of white-collar criminal denial. Karen's federal sentencing hearing had produced what legal scholars would later describe as one of the most comprehensive criminal penalties in Texas white-collar prosecution history. Judge Williams had sentenced her to 52 years in federal prison, $247 million in criminal fines, lifetime supervised release, and mandatory participation in psychological treatment programs designed for defendants with persistent delusional disorders. Mrs. Whitmore, you organized systematic fraud that destroyed the retirement security of 77 families, caused millions in environmental damage, and threatened federal witnesses when your criminal enterprise was discovered, Judge Williams had explained during the 3-hour sentencing hearing. Your complete lack of remorse and continued threats against law enforcement require maximum federal penalties to protect the community and deter similar crimes. Karen's reaction to her life sentence had provided her final moment of self-incrimination in federal court. This is persecution of successful Americans by corrupt tech billionaires and their government puppets, she'd screamed while being led away in shackles. I'll never apologize for building beautiful homes for families who deserved luxury living. The statement, broadcast internationally, captured Karen admitting that she considered systematic fraud to be legitimate business activity while maintaining that her criminal conviction was politically motivated persecution rather than legal consequences for documented crimes. Now, 18 months into her federal sentence, Karen's prison psychological evaluations revealed no improvement in her insight or remorse levels. Dr. Amanda Foster's quarterly reports describe persistent delusional thinking regarding perceived victimization and complete inability to acknowledge criminal behavior or accept responsibility for harm caused to victims. Karen's first cellmate, Maria Santos, had lasted exactly 2 weeks before requesting a transfer due to what she described as constant rants about tech billionaire conspiracies and corrupt federal judges. Her second cellmate, Patricia Williams, had managed only 5 days before filing harassment complaints about Karen's racist commentary on minority inmates and prison staff. Eventually, prison officials had placed Karen in protective custody due to her inability to coexist with other inmates without creating racial tensions and disciplinary problems. Her isolation only reinforced her delusional beliefs about being persecuted for telling uncomfortable truths about celebrity privilege and government corruption. Meanwhile, the environmental restoration of Karen's former criminal enterprise had become a showcase project for ecological recovery from illegal development. The valley where 35 luxury homes had once stood was now a thriving wetlands preserve that provided natural flood control for downstream communities while supporting native wildlife populations that had been displaced by Karen's construction activities. The restoration project, funded by federal asset forfeiture proceeds from Karen's criminal operation, employed techniques developed by Elon's environmental engineering team in collaboration with EPA restoration specialists. Native vegetation had been replanted, natural drainage patterns restored, and wildlife corridors established to support ecosystem recovery. Most importantly, the restored wetlands provided educational opportunities for environmental science students and policymakers interested in understanding the long-term ecological damage caused by illegal development in protected areas. The site became a model for environmental recovery that demonstrated how natural systems could be restored even after systematic destruction by criminal enterprises. the human recovery process was equally comprehensive. All 35 defrauded families had been fully compensated through Elon's property buyout program, which provided not just financial recovery but relocation assistance that helped families find legitimate homes in communities with proper environmental protections and legal development procedures. Robert and Margaret Chen, the elderly couple who'd lost their retirement savings to Karen's fraud, had used their compensation to purchase a smaller but legally owned home in Austin. Mr. Musk's generosity saved our retirement and restored our faith in American justice, Margaret explained during a follow-up interview. We learned that there are still honest people who protect victims of fraud rather than profit from their suffering. Similar testimonials from other victim families revealed the broader impact of comprehensive victim compensation that went beyond financial recovery to include psychological support, legal assistance, and community rebuilding that helped heal the trauma caused by systematic fraud. Karen's co-conspirators faced consequences proportional to their cooperation levels and criminal participation. Richard Whitmore, who'd cooperated fully with federal investigators after discovering his wife's fraud, had served 14 months in minimum security prison and was now working with environmental restoration organizations to rebuild his career and reputation. I spent 20 years building a legitimate construction business that my wife destroyed through criminal fraud, Richard explained during his parole supervision meeting. Now I'm working to rebuild my life while helping other construction professionals understand the legal requirements for environmental protection and proper permitting procedures. The other contractors and professionals who'd been manipulated into participating in Karen's fraud had received reduced sentences and were participating in community service programs focused on environmental restoration and fraud prevention education. Their cooperation had been essential for documenting the full scope of Karen's criminal enterprise and preventing similar fraud schemes. But Karen's influence continued causing problems even from federal prison. Her jailhouse phone calls, monitored by prison officials, revealed ongoing attempts to recruit family members and former business associates for what she called political persecution defense campaigns and victim rights advocacy that were actually attempts to harass federal prosecutors and intimidate former co-conspirators who'd testified against her. One recorded phone call to her estranged sister Patricia captured the full extent of Karen's continuing delusions and complete inability to accept responsibility for her criminal behavior. "Patricia, you need to organize community support for my appeal," Karen instructed. "I have evidence that this whole prosecution was organized by tech billionaires to silence honest Americans who expose government corruption. The environmental restoration is just propaganda to cover up their illegal land grab." Patricia's response, also recorded, demonstrated why Karen's family had universally severed contact with her after her conviction. "Karen, you defrauded 77 families and destroyed protected wetlands to steal millions of dollars. There's no conspiracy, there's no corruption, there's just you refusing to accept responsibility for systematic criminal behavior that hurt innocent people." The phone call ended with Karen screaming about family betrayal and brainwashed relatives before prison officials terminated the conversation and further restricted her communication privileges. Dr. Foster's final psychological evaluation before Karen's first parole review concluded that she remained a danger to the community and showed no capacity for rehabilitation or remorse. Subject continues to exhibit severe narcissistic personality disorder with persistent delusional thinking about her criminal conviction. Shows no insight into her behavior, no empathy for victims, and continues planning harassment of prosecutors and witnesses. Prognosis for successful reintegration into society remains extremely poor. The Parole Review Board, faced with Dr. Foster's recommendations and Karen's continued threats against federal prosecutors, denied her application and scheduled her next review for 10 years later. Legal experts predicted that Karen would serve her full 52-year sentence due to her continued criminal thinking and ongoing threats against law enforcement. Meanwhile, the precedent established by United States v. Whitmore had become a powerful tool for environmental prosecutors handling similar cases nationwide. The comprehensive evidence collection methods, successful prosecution strategy, and substantial sentences served as both deterrent and blueprint for future environmental fraud prosecutions. Law enforcement agencies developed training programs based on Karen's case, teaching investigators how to recognize systematic environmental fraud and understand the federal implications of illegal development in protected areas. The training materials included Karen's own recorded statements and social media posts as examples of how criminals often document their own illegal activities while justifying them through entitled thinking. The case also influenced federal legislation regarding environmental protection and real estate fraud prevention. The Environmental Fraud Prevention Act, introduced in Congress 2 years after Karen's conviction, required enhanced disclosure requirements for development projects, and provided additional criminal penalties for systematic environmental crimes. Most importantly, Elon's response to Karen's criminal land theft had demonstrated how victims of systematic fraud could achieve both legal justice and practical restoration through comprehensive engineering solutions combined with traditional law enforcement procedures. The controlled flooding demonstration had become a case study taught in environmental engineering programs, showing how natural systems could be used to document environmental crimes while providing compelling evidence for federal prosecution. The combination of scientific methodology and legal strategy had created a model for addressing environmental fraud that protected both victims and natural ecosystems. 3 years after Karen's conviction, the restored wetlands attracted thousands of visitors annually who came to learn about environmental protection, ecosystem restoration, and the consequences of illegal development in protected areas. The site featured educational displays about Karen's criminal enterprise and the legal processes that had restored the area to its natural state. The display included before and after photographs showing Karen's luxury development and its transformation back into thriving wetlands, demonstrating visually how criminal enterprises could be reversed through comprehensive legal action and environmental engineering. As I concluded my documentation of this case while preparing the final report for Elon's legal team, I reflected on the mathematical precision of consequences in Karen's story. She'd started with property envy, escalated through systematic fraud and environmental destruction, and ended with federal prison time that would last longer than some people's entire careers. But more importantly, her criminal enterprise had accidentally created positive changes that extended far beyond environmental restoration. Federal prosecutors had gained new tools for handling environmental fraud cases. Environmental engineers had developed innovative restoration techniques. Victim families had received comprehensive compensation and support that helped them rebuild their lives. Karen Whitmore had intended to steal land and defraud innocent families to build her luxury development empire. Instead, she'd accidentally created a more effective environmental protection system while destroying her own life through systematic criminal behavior and complete inability to accept responsibility for her actions. The lesson was clear and comprehensive. Environmental fraud has federal consequences that don't disappear when you realize you've made terrible choices. Federal prosecutors, federal judges, and federal prisons don't care about your previous social status, your country club memberships, or your theories about tech billionaire conspiracies. As Karen continued serving her sentence in federal prison, wearing orange jumpsuits instead of white tennis outfits and writing delusional appeals that courts routinely dismissed, the wetlands preserve that had replaced her criminal enterprise continued thriving as a testament to environmental recovery and legal justice. Sometimes justice takes time and requires both traditional law enforcement and innovative engineering solutions. But when it succeeds, it's comprehensive, educational, and exactly what environmental criminals deserve for thinking they can destroy protected ecosystems without facing serious federal consequences. The war between Karen's criminal entitlement and environmental protection laws had ended with complete victory for legal justice and ecological restoration, proving that some problems require solutions that combine courtroom victories with practical demonstrations of natural water flow patterns and the consequences of building luxury homes in flood zones controlled by people who understand both environmental law and hydraulic engineering.